Good afternoon, Mr. Wilson.
How are you, Your Honor?
Good. Is anybody else going to be joining us on Zoom?
Mr. Hall should be around somewhere.
I'm sorry.
Tom Hall is going to be the witness.
Okay.
I'm not sure where he is.
Don't either. I am going to ask you to turn up your volume, though. I can barely hear you, and I'll remind you that we are live streaming on YouTube today.
That's as high as I can go. Is that okay?
Well, it's about the same.
Oh, well, I'll try to speak a little louder.
All right. Thank you.
Well, if Mr. Hall doesn't join us, this is a fairly straightforward matter. Mr. Hall was retained by the dependent administrator pursuant to a court order authorizing him to be paid a contingency fee. And he sued.
Mr. Wilson, I'm sorry. You're going to have to look at the screen and speak up towards the whatever time you go down. I can't
Okay.
hear you.
Yes, Your Honor. Okay, Mr. Hall was retained to sue people that the administrator believed was responsible for the death of Mr. Robinson. And he has settled with the, well, let me back up a little bit. So it's about, Mr. Robinson was operating a forklift, and it ran over him. And when they, according to what Mr. Hall tells me, when the employer tried to get the forklift off of Mr. Robinson, they dropped it on top of him a second time, which resulted in his death. So Mr. Hall sued the employer and has also sued the manufacturer of the forklift. And the settlement he has negotiated is with the manufacturer of the forklift. And he and the beneficiary, the surviving spouse, and the executor have agreed that the $22,000 offer is a fair offer, given the fact that the manufacturer of the forklift has an expert witness who basically said the employer should have had all of these warning stickers on this forklift that they didn't have, and they either took them off or didn't install them when the forklift was delivered, and that the employer was therefore grossly negligent. And Mr. Hall thinks there should be a substantial recovery against the employer. But he, as part of this settlement, he is going to get access to the manufacturer's expert witness who will testify to the negligence and gross negligence of the employer. So what Mr. Hall's asked me to do is get his the settlement approved and authorize him to disperse from that settlement his fees and pay his out-of-pocket expenses, and some of which includes fees that the court's already approved for me.
Okay, no, wait, you say the fees are already approved for you?
Yeah, they were some time ago.
On those fees?
Marcia, do we have an order on those fees? Okay, what's the docket number?
I just had today, December 26, 2019.
December 26, 2019. $5,385.17.
5,000 what?
$5,385.17.
Okay, and that was one of my questions. Also, this allocation doesn't allocate between the estate and the alleged surviving spouse. And it also doesn't allocate between the survival claim and the wrongful death claim. So while I realize only $281 is actually coming to the hands of the estate and the wrongful death beneficiary, I still have no way to allocate it. So
I think what we were proposing is to place the money in Mr. Hall's trust account and just leave it there until the other claim is resolved.
I understand that that's what you want to do with the money, but that still doesn't clear the issue of this settlement is not allocated either to survival or wrongful death or between the two settling parties. So something needs to be done about that, because I don't want to be here arguing about $281 later. And also, only I'm not the other person's attorney, obviously, but estate expenses come from the estate. And if there's anything that's allocated that's coming out of here that should be to that person, it should be to that person, not on the
Right,
estate.
okay. Okay, I'll get an estate account open for Anna, Ms. Robinson. I believe it's-
Mr. Wilson, I didn't ask for an estate accounting. I need to know what part of the $22,000 goes to wrongful death and what part goes to survival. The estate owns 100% of the survival claim, so
Right.
that would all go towards the estate. Now,
I think 100%.
death is going to be towards the heirs. They'll have to allocate that among themselves. I'm assuming that perhaps the surviving spouse is the only heir.
I think that surviving spouse
Gentleman is
No.
only, sir, can I please finish?
Yes, ma'am, I'm sorry.
The, we only have a surviving spouse and an estate person settling. I'm assuming that those are the only heirs. I can go look back at the heirship determination. But I need to know those allocations. That needs to be in either the settlement agreement or an amended motion to approve.
Okay, I can do that. I'll get with Mr. Hall on that. I'm not sure why he is not here, but something must have happened. I can amend the application and allocate it, but you're correct. The survival cause of action is going to go to the surviving spouse, and the estate, she's the sole beneficiary of the estate too, or not beneficiary, sole heir.
Okay, well, yeah, it doesn't go to her directly. It goes to the estate, and we may have creditors as well at the estate. So
Right.
creditors
Well,
may
yeah,
have a piece of whatever is allocated for the survival action. I don't know the details of the case, and Mr. Hall's not here to tell us. So I don't know what, if it was instant, so they're not saying there's much of survival other than maybe funeral expenses or what. I can't guess to that, but I can tell you I've done a lot of these cases as actually an attorney. So I understand that, and we've got to have that allocated either in an amended motion or actually in the settlement agreement.
Okay. I'll get with Mr. Hall. We'll amend it. We'll get the settlement agreement amended, and then we'll send the application back to the court to approve that allocation. And we'll have, I guess, of course, what goes to the estate goes to the administrator. She does not have an estate account at this point in time. Would the court have any problem me placing the estate's portion of the accounts in my trust account?
As long as you get a court order saying that, or it can go into the registry of the court.
Well, I think it'd be cheaper to put it in my trust account, but I'll put that in the proposed order, Your Honor.
Okay. All right.
Try to find out where Mr. Hall apparently had some computer problems. I'm not sure what happened.
Okay. All right. Well, I'll hope to see you in person next time.
Okay, thank you, Your Honor.
Thank you. If you're joining us on YouTube, welcome to probate court number 2. I'm Judge Brooke Allen. We're in between hearings right now. We do one Zoom for usually our morning and usually our afternoon docket, because otherwise we would be wasting a lot of precious time signing into Zoom and then signing either into YouTube or Facebook. And that's time we can spend hearing cases instead of technical issues. So I am going to put my screen share on, and I will see you guys back around 3 o'clock when we will continue our hearings. The next thing is a prevent of a will, and it is a copy of a will. So it should have quite a few people. Hopefully it will all go smoothly technical wise so that we can focus on the substance. Good afternoon, Mr. Lynn, and welcome to probate court number 2. I know you were changed from an in-person hearing to a Zoom hearing, so I didn't see a Zoom hearing letter on file. So can you let me know who's with you today and whether you have a notary present?
My notary is my legal assistant, Your Honor. She just went back up front to man the phones. Would you like her back here right now?
Well, it's better to have the notary that's there swear them in, but I can also swear them in because
Okay,
thing's been suspended.
okay, well, happy to do so. Happy to do so.
All right.
We'll
Who else is
get
with
her.
you?
This is Marcia Yvette Gentry that is with me, Your Honor.
Okay.
She's the applicant.
Okay. Anyone else?
I couldn't hear you, Your Honor.
Anyone else?
This is the notary right here, right here.
Okay. Do you have any other witnesses?
I do have the son, the grandson that's here, Aaron Gentry. He's here, Your Honor.
Okay. If our witnesses will please raise their right hand. And if our notary will ask them if they swear to tell the truth, the whole truth, and nothing but the truth, so help them God.
Do you just swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. And Mr. Lynn, I'll remind you that we are live streaming on YouTube. So while I know that we sometimes ask specific addresses and specific items, I need you to meet your burden under the law as to state or county, depending on what you're talking about. But for the privacy of your client and the witnesses and the decedent, please don't get too specific.
All right, thank you, Your Honor. May I proceed, Your Honor?
Please.
Your Honor, I'd like to call Marcia Yvette Gentry, Your Honor.
Okay.
Marcia Yvette Gentry, are you the applicant in the first amended application for the probate of the will of Jane Elizabeth McCann, deceased?
Yes,
And you're asking the court admit the will to probate and issue letters testamentary pursuant to section 401.002A of the Texas Estates Code. Is that correct?
yes,
All right. And you are an individual interested in this estate. Is that correct?
yes,
And you are domiciled in and reside in Colorado. Is that correct?
yes,
All right. And you're serving, and basically you live in Colorado Springs, Colorado. Is that correct?
yes,
Okay. Are you the only child of Jane Elizabeth McCann, the decedent?
yes,
All right. Are you also a distributee of the estate of Jane Elizabeth McCann, deceased?
yes,
There are 2 other distributees of the estate of Jane Elizabeth McCann, deceased. Is that correct?
yes,
And those are your 2 children, Aaron Brian Gentry and Adam Jeffrey Gentry. Is that correct?
yes,
And therefore they are the only grandchildren of Jane Elizabeth McCann, deceased. Is that correct?
yes,
Your mother, the decedent, died on October 7th, 2019 in Grapevine, Tarrant County, Texas at the age of 98 years. Is that correct?
yes,
She was domiciled and had a place at the time of her death. When her domicile at the time of her death was North Richland Hills, Tarrant County, Texas. Is that correct?
yes,
You're stating the court has jurisdiction and venue is proper because the decedent was domiciled in Texas and had a fixed place of residence in Tarrant County, Texas on the date of her death. Is that correct?
yes,
And you're stating that decedent owned property described generally as cash, personal effects, and household goods of a probable value in excess of $7,500. Is that correct?
yes,
The decedent left a valid will dated March 13th, 2004, which was never revoked. Is that correct?
yes,
A true and correct copy of the will was filed with the court. Is that correct?
yes,
The will that was filed with for probate was a true and correct copy of the original will because the original will was lost. Is that correct?
yes,
On March 13th, 2004, the date that your mother, Jane Elizabeth McCann, signed her will, she was living in Tyler, Smith County, Texas. Is that correct?
yes,
On that same day, your mother also signed a durable power of attorney for financial management, naming you, the applicant, as her attorney in fact. Is that correct?
Yes.
That said power of attorney was filed in the county records of Smith County, Texas on March 15, 2004. Is that correct?
Yes.
The witnesses on that said power of attorney, the same witnesses on the will of Jane Elizabeth McCann, being Gene F. Rowlett and Robert B. Rowlett. Is that correct?
Yes.
Subsequent to March 13, 2004, your mother moved to Tarrant County, Texas to live near one of her two grandsons, Aaron Brian Gentry, who's here today. Is that correct?
Yes.
And he resides in Hurst, Tarrant County, Texas. Is that correct?
Yes.
All right. And your mom died in Tarrant County, Texas on October 7, 2019. Is that correct?
Yes.
And shortly after that, you learned that one of the bank accounts of your mother did not have a named beneficiary. Is that correct?
Yes.
And that you would have to probate your mother's will. Is that correct?
Yes.
So then you began to search diligently for the records in your home in Colorado, as well as the records of the decedent and decedent's residence in North Richland Hills, Tarrant County, Texas, looking for decedent's original will. Is that correct? And you could only find a true and correct copy of the will of Jane Elizabeth McCann that's been filed with the court in this case. Is that correct?
Yes.
The search was made in the county records of Smith County, Texas for the original will of Jane Elizabeth McCann. Is that correct?
Yes.
But it was never filed there. Is that right?
Yes.
And therefore you've looked everywhere that you could think to search, but you've never found the original will of Jane Elizabeth McCann. Is that correct?
Yes.
All the distributees of the estate of Jane Elizabeth McCann deceased are aware of that fact, and they've all signed an affidavit of waiver of notice of citation of a will not produced in court. That's been filed with the court. Is that correct?
Yes.
You say the distributees are yourself, Marcia Yvette Gentry, living in Colorado Springs, Colorado, Aaron Brian Gentry, living in Hurst, Texas, and Adam Jeffrey Gentry, living in Whangarei, New Zealand. Did I say that
You
right?
did say that right.
All
Yes.
right. All right. And then basically you're stating that if Jane Elizabeth McCann had died without a valid will, then the entire estate would have passed to her only child, that being you, Marcia Yvette Gentry. Is that correct?
Yes.
All right. And you are also the mother of the only grandchildren, Jane Elizabeth McCann, Aaron Brian Gentry, and Adam Jeffrey Gentry. Is that correct?
Yes.
All right. The contents of the original will of Jane Elizabeth McCann are set forth in the file marked true copy of the will of Jane Elizabeth McCann. Is that correct?
Yes.
It states that Marcia Yvette Gentry served as executor and that the residuary estate is left to Aaron Brian Gentry, Adam Jeffrey Gentry, and Marcia Yvette Gentry in the following shares. Aaron Brian Gentry shall get 1/4 share. Adam Jeffrey Gentry shall get a 1/4 share, and Marcia Yvette Gentry shall receive a 1/2 share. Is that correct?
Yes.
Right. The said will did not state that Jane Elizabeth McCann was leaving a specific bequest. Is that correct?
Yes.
Therefore, all the assets of the estate of Jane Elizabeth McCann deceased would be the residuary estate of Jane Elizabeth McCann deceased, according to the definition of residuary estate is set forth in the said will. Is that correct?
Yes.
All right. Are you also stating that a necessity exists for the administration of the estate, specifically that the decedent owned a bank account that requires that ownership of such account may only be transferred pursuant to instructions signed by a personal representative in letters testamentary or letters of administration have been issued by a court of competent jurisdiction? Is that correct?
Yes.
After the date of the will, no child was born to or adopted by the decedent. Is that correct?
Yes.
No marriage of the decedent was ever dissolved after the will was made. Is that correct?
Yes.
The decedent's will named you to serve as executor. Is that correct?
Yes.
And you reside in Colorado Springs, El Paso County, Colorado, correct?
Yes.
The will does not provide for an independent administration. However, there exists a necessity for administration of the estate. Is that correct?
Yes.
Distributees agree on the advisability of having an independent administration and designate you, Marcia Yvette Gentry, as independent executor and request that no action be had in the statutory probate court in relation to the settlement of the decedent's estate other than a probate and recording of the will and return of the inventory, appraisement, list of claims, or an affidavit in lieu of the inventory. Is that correct?
Yes.
You are not disqualified by law from serving as such or from accepting letters testamentary, and you'd be entitled to those letters. Is that correct?
Yes.
Because you live in Colorado, you appointed your son, Aaron Brian Gentry, who lives in Hurst, Texas, to be the resident agent. Is that correct?
Yes.
No state governmental agency of the state or charitable organization is named by the will as a devotee. Is that correct?
Yes.
And the will is made self-proved in a manner prescribed by law, and the subscribing witnesses to the will are Gene F. Rowlett and Robert B. Rowlett. Is that correct?
Yes.
You, Marcia Yvette Gentry, Aaron Brian Gentry, and Adam Jeffrey Gentry are the distributors of the state, and the only persons required to receive notice under section 401.004 of the Texas States Code. Is that correct?
Yes.
And you, Marcia Yvette Gentry, Aaron Brian Gentry, and Adam Jeffrey Gentry each have filed a distributee's consent to application for independent administration and waiver of notice. Is that correct?
Yes.
And the independent administration decisions of state pursuant to section 401.002A of the Texas Estates Code is advisable in the best interest of the decedent state and of the heirs and distributors of that state. Is that correct?
Yes.
Now let's take a look at the will. I'm showing you the file mark copy of the will.
Yes.
And basically say, have you seen this document before?
Yes.
All right. Is this the last will and testament of your mother, Jane Elizabeth McCann?
Yes.
All right. Do you see her initials on each of the pages of the will?
Yes.
All right. On page 4, there's a signature. Is that the signature of your mother, Jane Elizabeth McCann?
Yes.
All right. And then under the self-proving affidavit, there's a signature of the testator, Jane Elizabeth McCann. Is that your mother's signature?
Yes.
Are you then respectfully requesting that the court admit this will to probate
Yes.
and that the court appoint you the independent executor of the estate
Yes.
and the court grant you letters testamentary?
Yes.
Your Honor, so respectfully requested. Would you like me to call my next witness, Your Honor?
Well, I have a couple questions. I may have missed this. I saw you've appointed a registered agent, but as far as disqualifications, have you ever been convicted of a felony?
Is that for me, Your Honor?
Well, our applicant, Ms. Gentry.
No, ma'am.
Oh, for me? No,
You're-
I have not. Mm-mm.
Okay. Have you ever been adjudicated incompetent?
I'm sorry, incompetent?
Correct.
No.
Okay. And you are inheriting under this will, correct?
Yes.
Okay. All right. You can call your next witness.
Your Honor,
Here, let me move over.
I'll switch seats. Your Honor, I call Aaron Gentry, Your Honor.
Okay,
May I proceed, Your Honor?
please.
All right. Are you familiar with your grandmother's signature?
Yes.
All right. I'm showing you her last will and testament. Looking on page 4, the last will and testament, is that the signature of your grandmother, Jane Elizabeth McCann?
It is.
All right. I'm also looking at underneath the self-proving affidavit and the testator, Jane Elizabeth McCann. Is that her signature?
Same signature, yes.
Okay. And you've known your grandmother from the time you could know anything as a child, baby, up until the day of her death. Is that correct?
Correct.
All right. Let me ask you too about the members of the family. The only child of your mother, the only child of your grandmother is your mother, Marcia Yvette Gentry. Is that correct?
That's correct.
And the only 2 grandchildren that your grandmother had are you, Aaron Brian Gentry, and your brother, Adam Jeffrey Gentry. Is that correct?
That's correct.
All right. The will basically states that you and your brother and your mother are to each receive a share of the residuary estate, you getting a 1/4 share. Is that correct?
That's correct.
And your brother, Adam Jeffrey Gentry, receiving a 1/4 share. Is that correct?
That's correct.
And your mother, Marcia Yvette Gentry, receiving a 1/2 share. Is that correct?
That is correct.
All right. And you and your brother also signed a document stating that you wanted the independent administration. Is that correct?
That's correct.
All right. Are you stating to the court that you want this will admitted to probate?
Yes.
Are you stating to the court that you want your mother appointed as the independent executor of the estate?
Yes.
Are you also stating to the court that you would like your mother to receive letters testamentary?
Yes.
It's so respectfully requested, Your Honor.
Okay, do you have any other witnesses?
No other witnesses, Your Honor.
Okay. Mr. Lynn, I can't grant your application today. You have to have a disinterested witness testify to the signature of the decedent because it's a copy of the will as stated in the statutes. Anything else for today?
I couldn't hear you, Your Honor.
Your application is denied because you haven't proved your burden under the statute.
All right. Well, then I will make an amendment then, Your Honor.
Okay, thank you.
Thank you.
Hello,
Hi, Judge.
probate court 2. How are y'all?
Fine, thank you.
Good. We're here on the application for acceptance of a foreign guardianship of the person of Lynn A. Koch. I will remind you that we are live streaming on YouTube. So for the protection of Ms. Koch and our applicant, if you'll please not talk about specific addresses and those types of things, but of course I do need you to meet your burden under the law. Ms. Craven, who is with us today?
I have Dr. Charles Payerly Jr. He's the applicant in this cause.
Okay. Mr. Parley, will you please raise your right hand?
I believe he's still muted.
Well, I'm trying to unmute him.
There we go. Thank you.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. I'm not sure if Mr. Arnier was going to join us. We're a few minutes early. But okay, I'm gonna let you go ahead. I may add him if he pops in here.
Certainly. May it please the court, I'd like to call Charles R. Payerly Jr.
Okay,
Mr. Payerly, please state your name for the record.
Charles Richard Parley Jr.
And you are the applicant in this cause, is that correct?
Correct.
And you reside in Tarrant County, Texas, is that right?
Correct.
And we're here on behalf of your sister, Lynn A. Koch, is that correct?
That's correct.
And she is a female born in July of 1968, approximately 51 years of age, residing in Arlington, Texas. Is that correct?
Correct.
And she is in a care facility there in Arlington, Texas, correct?
Yes.
Did you place her there as a successor standby guardian appointed by the court of the Nassau County, New York?
Correct.
And are you here asking this court to accept the guardianship established in New York, receive that guardianship, and appoint you under Texas law as guardian for your sister?
That is correct.
I'm going to ask you a few questions about your sister. Now, she has some incapacities, correct?
But yes, she does.
What do you understand those incapacities to be?
She has limited short-term memory. She's unable to process new information and able to carry out really any functions of living because of that. Basically, every day is a new day to her. She does not retain new information and process it for anything. You probably up to 15 minutes is about as long as she can retain something.
When you first moved your sister to Texas, did you have her see a physician named Frank Jurek?
Jursic.
Jursic.
I did.
And did you cause to be filed in this cause a physician certificate of medical exam?
Correct. Yes.
Did you review that diagnosis of anoxic encephaly due to thromboemboli?
Correct. Yes.
Do you agree with the detail in that physician certificate of the levels of incapacity and need for a total guardianship of the person?
I do.
Do you believe, along with this doctor, that your sister is not of capacity to care for her person, her money, basically her day-to-day living activities, and suffers as such?
I do.
Your Honor, I ask court to take judicial notice of the application on file, the citations that have been served, and the physician certificate of medical exam we'd like to offer into evidence.
okay, it's submitted.
Dr. Payerly, can you tell us a little bit about the estate of your sister? And I'll lead you through some of that. She has a supplemental needs trust that holds her money that includes monthly payments from the California disability. Is that correct?
Yes, that's correct.
And are you the trustee of that trust at this time?
Yes.
And are you taking care then of the monthly expenses for your sister under that trust?
Yes.
Okay. And your sister also has another supplemental needs trust that's a third-party trust established by your mother. Is that correct?
Correct.
And that trust received all of the assets belonging to Lynn Coke from the estate of your mother, Adele. Is that correct?
That's correct.
And are you the trustee of that trust as well?
I am.
Right. And sadly, the daughter of your sister, Lynn Coke, had passed. She was 18 years of age, and she died prior to this guardianship hearing. Is that correct?
That's correct.
Now, there's been some time since this filing. Did anything surface belonging to your sister from the estate of her daughter?
No, no,
Did she die with any assets?
no, she didn't.
At the age of 18, did she die with a will?
No,
Right. So at this time, you're not in possession of anything additional outside of these trusts that belongs to your sister. Is that correct?
that's correct.
At this time, do you see any need for a guardianship of the estate over your sister for funds not held in trust?
In the sense, I'm sorry, I don't understand, like
Do
separate
you
from
see-
me?
Is there anything that you would be holding as a guardian outside of these trusts that are financial resources of your sister, Lynn Coke?
No, no, there's nothing.
So there's no need at this time to go forward with a guardianship of the estate. Is that correct?
That's correct.
All right. So you are proposing that you be the guardian of the person of your sister, Lynn Coke. Is that correct?
Correct.
And we've discussed suitability and qualifications by law. Is that correct?
Yes,
And you are not a person that's been found by a court to be incapacitated. Is that right?
that's right.
And you do not have felonies or any acts of moral turpitude found by a court to be unsuitable to serve as guardian. Is that correct?
That's correct.
All right. Do you have any financial claims or commingling related to your sister, Lynn Coke?
I don't, no,
Does she owe you any money?
she does not.
Do you owe her any money?
I do not.
Are you the executor of your mother's estate?
I am.
And for the record, what is her name?
Adele Pearley.
And Adele was the initial guardian of the person of Lynn Coke. Is that correct?
Yes.
As the executor in New York State for your mother's estate, do you know of any other resources or assets that might become those belonging to your sister held outside of trust?
The only part of the estate is the real estate that we have in New York right now that isn't even on the market yet. You know, the value of the house will then go into whether it goes into the trust or not is kind of an open-ended issue right now. I don't even know the status of sales of that, but it will be used for her care.
Okay. In your mother's will, has it been accepted into probate in New York State?
It has, finally, yes.
Okay. And in that will, did it leave anything to your sister outside of trust?
No, not outside of the trust.
So the sale of the property, that any interest that belongs to your sister would actually go into her trust that her mother set up for her. Is that correct?
There were two major items as far as the trust go. One was her pension, which is 100% going into the trust. The remaining was the value of the real estate, which is outside of the trust. Anything outside of the trust was left to me individually. I don't need it. It's going to go for her care. Whether I actually place it into the trust or not, I haven't come to a final conclusion on that yet.
Okay. But the will leaves all the real estate and interest in real estate, including the proceeds of the sale of real estate, to you personally.
Correct.
Is that- all right.
Correct.
if you are appointed guardian of the person, you understand you would be required in Texas to file a report annually to the court as to your sister's care and her well-being.
Correct, yes.
And you understand that if you are to decide to have assets held outside of these trusts for your sister, that the court would need to know and open a guardianship of the estate or consider that for any assets belonging to your sister outside of the trust.
Understand.
You're asking that the court grant a guardianship that gives you all the rights and duties under the Texas Estates Code to be the guardian of her person. Is that correct?
Yes,
And to restrict the rights, civil rights belonging to your sister under the Constitution that allow her to travel, marry, her right to vote, all of those things. Are you asking this court, based on her limited capacity, to restrict those fundamental freedoms and rights?
I am, yes.
I'll pass the witness.
Okay. The first party special needs trust, where did you say that money is coming in from?
She has a disability pension from the state of California. She
Okay,
receives a monthly disability check.
thank you. Okay, anything else, Ms. Craven?
Just a clarification, since you mentioned that particular trust, does it also hold the 403B Vanguard and Janus accounts of $15,000
Correct, yes.
in addition to the monthly amounts coming in?
That's correct, yes.
Okay. Anything else?
That's all I have, Your Honor.
Okay, I want to clarify, this is not a proceeding to establish a guardianship. The guardianship was already established by the state of New York. They deemed Ms. Koch to be an incapacitated person. They took away her civil liberties. The issue here is whether this court will accept the guardianship from New York since Ms. Koch is living here. So I want to make that very clear because we would not be having a TV hearing to take away someone's civil liberties, because I think that's fundamentally wrong. And I don't think I can preserve and protect constitutional rights and due process of people over TV. So if anyone's joining us on YouTube, I want to make that perfectly clear that that's not going to go on in probate court too, as long as I am the judge. However, because those things have already been adjudicated, and we do give full faith and credit to our orders from other states, I will accept the guardianship of the person only. Ms. Craven, I have a different order I'm signing that specifies that we are accepting the foreign guardianship of the person, and that I am giving the rights of Dr. Pearley the same rights that the New York court gave him. That's really the only thing in front of me right now. Of course, as a guardian of the person in Texas, he has the rights under Texas law as well. And I have specifically stated we are not accepting the foreign guardianship of the estate for reasons articulated during the hearing. So I'm going to sign that order, and then you can file what needs to be filed. And Dr. Pearley, thank you for taking care of your sister, and I look forward to seeing your reports.
Wonderful. Thank you very much.
Thank y'all. Have a great
Thank you, Your Honor.